Good morning to all. I read c'è un programma qui. I give the floor to Stefano Palmieri, President of the Section of Economic and Monetary Union, Economic and Social Cohesion, European Economic and Social Committee. Thank you.
Thanks, Mr. President. Dear ladies and gentlemen here in the meeting room, dear distinguished speakers, dear guests that are connected online. On behalf of your host today, the European Economic and Social Committee, I would like to heartily welcome all of you here in our premises, the House of European Organized Civil Society. When I learned about your plan to hold this conference here in the committee, I was immediately interested, as this is a topic very close to our core business, a transparent economic system with no room for illegal activities and money laundering activities. And this aim comes from all the three main groups of our committee: entrepreneurs, workers, and other civil society organizations. So I made myself available to address you some welcoming words and to kick off the day with input on the fight against money laundering from a civil society perspective. I'm here in this committee as the President of the Section for Economic and Monetary Union and Economic and Social Cohesion, and we have in the last years in our section dedicated a lot of work and action dedicated to a fight against the plague of money laundering and the financing of terrorism and how to best counter them. Because this is a plague that alters the level playing field of the internal market and the competitiveness of the whole EU economic system. As you know, our committee is consulted in the legislative process by the two legislative chambers of the EU, European Parliament and the Council. Further to that, the IC can also drive up own initiative opinion, and this is an important task for us. In this context, during the last years, first in the ECO section and then in the IEC plenary, we adopted opinions that give observation and policy recommendation on policy proposals coming from the European Commission, namely on the anti-money laundering perspective legislative package 2021 and the revision of anti-money laundering directive of 2016, as well as on the fight for the use of shell entities. And in addition, our committee developed and adopted an own initiative opinion on combating tax fraud, tax avoidance, and money laundering. This last opinion and the one on the shell entities might be of special interest for you, as they make also reference for the activity of the professional enablers and the role that they play. The IC concludes that the cooperation of professional supervisory bodies in combating malpractice and possible criminal activity carried out by professional enablers will be of great value. The organizer of today's conference have gladly agreed to make links to all the IEC opinion I mentioned before available on the conference website at some point after today's event. So anyone who wishes to have a closer look is invited to do so. I am also very happy to announce that my colleague in IEC, Javier Dos Oris, who has been working as a rapporteur or co-rapporteur on all of the opinion I just mentioned, has been invited to speak in the panel starting at 2 and 45, which deals with the current state of anti-money laundering and future development, and more specifically with the work of the European institution. Now, coming toward the end of my introduction, I would like to affirm once more that for me personally, the fight against the money laundering is of utmost importance and has to be stepped up. As the ECO-section president, I, for example, contribute personally to a task force of the Centre for European Policy Studies here in Brussels that is led by Karel Lanou, and I fed in with the policy recommendation of organized civil society. And I also initiated the organization of 2 high-level conferences in the ECO-section. On 5th October 2021, on the anti-money laundering legislative package, where we took stock of the state of play in the fight against the ML and debated in particular the legislative proposal that had been tabled by the European Commission in July 2021, with the aim to strengthen the EU anti-money laundering and countering terrorism financing rules. Early the same year, we had already organized an event with a different focus, the economic impact of organized crime and money laundering. How does the COVID-19 crisis aggravate the problems? And in this project, there are members that came from Italy, Spain, Bulgaria, and they know very well the important and delicate and serious situation of the introduction of mafia inside the economic activity. As well as we know, the activities of organized crime organizations like money laundering and the tapping of public funds have consequences for the economy, business and society. And a crisis like the COVID-19 pandemic was an opportunity for organized crime to spread their activity, gain power and even innovate to find new ways to pursue their objective. We had at the event as a special guest Federico Cafiero de Rao, National Anti-Mafia and Anti-Terrorism Prosecutor of the Italian Republic. The record of the 2 conferences could be found in our website in the ECO section and could be very interesting for you. Before you start the debate, let me conclude by telling you some of the most important points that have emerged for the European Economic and Social Committee in the past work. The IEC finds current European AML legislation largely inadequate in the face of coordination failure and national divergences. The IEC therefore strongly supports the Commission anti-money laundering legislative package of 2021, in particular, the creation and design of the new European Anti-Money Laundering Authority. That agency should be given sufficient resources to become the core of the integrated European oversight and intelligence system. Furthermore, anti-money laundering should be made operational as soon as possible and already in 2026. We ask for the activation in 2026 of this agency. The IEC reiterates its proposal for a social and political European pact to combat behaviour that damage the ethical and political principle of our democracy and undermine public good. The committee proposed the creation of a civil society advisory body within the MLA or under the European Commission. And the IEC is happy to see that there has been, in the meantime, an agreement by the co-legislator on the EU regulation of crypto assets, the so-called MiCA proposal. It is a matter of urgency to defend ourselves against the financial and criminal risk of these new financial products. Some issues in the fight against money laundering are, however, not yet addressed properly. The IEC therefore calls on the Commission to consider how to apply the legislative package to money laundering channel outside the financial system, and by that I mean notably the market in works of art and high-value assets, free port, custom, warehouse and special economic zones, certain commercial or trade transaction, real estate investment and gambling. Additional EU legislation will be needed in this area. The IEC also proposed that Europol be given a greater power and sufficient resources to carry out its work in the field of AML. Effective coordination of the European Public Prosecutor's Office, Europol, and the new anti-money laundering authority may be the key to practical success of the legislative package. The IEC, furthermore, calls on the Commission to push for the urgent transposition in all Member States of the common definition of the offence of money laundering and for a new common definition of related offences, including corresponding penalties. On a different angle, our committee proposes that the European Commission enact a rule that companies and individuals involved in financial crime or money laundering should be absolutely excluded from public procurement procedures. And to conclude, I also mention the point on which Javier will elaborate in more detail. The IEC is very concerned about the existence in the EU of a huge number of shell companies, which play a key role in money laundering and tax avoidance. It proposed to monitor these companies and the firms that manage them in order to identify their real owners and those responsible for their transaction and to investigate any crimes they may commit. Ladies and gentlemen, a lot can be done to fight money laundering, especially if forces are bundled and if we are pulling on the same rope. The legal profession play an important role and have a big responsibility in this. And for that, the LIGHT project and this conference today is definitely a very important initiative. I'm really sorry that I can't follow your work because in the meantime I and Pietro will have to attend the President Bureau of this committee. In any case, I wish you an interesting debate today, and should there be any further question on the IC position, then my colleague Javier is ready to go into more detail, and in any case, I hope we have the opportunity in the next future to continue this work, in this work that is really important for our future and for the future of our child. Thanks.
Thanks, Mr. Palmieri. I would like to leave the floor to Mr. Piero Dell'Otto, President of the CCMI, who is a pleasant addition to our agenda.
Dear Mr. President, dear Gaetano, thank you so much for having me here for this very last minute, I would say, invitation, but I'm very delighted to be here among us. My warmest welcome. I will spend very few minutes and words, but not just to welcome you as such, but also to address some key words. I'm president of CCMI. CCMI is a consultative commission on industrial change, the SICA, if you remember. A commission established after the deadline, the expiration of SICA institution, the first and maybe probably the best one we had in Europe, the most effective and powerful. But as a poor economist, I'm so sorry for that. I'm not, you know, this is my cross. I would like to address some points that we are dealing with liberal professions, not just legal. We are engaged in the transformation in the twin transformation. It means the digital one and the green one. In the context of the global competitiveness of European industries. But if we think that the 96 to 98% of European companies are small and medium sized, I think and I truly believe that all the efforts that we can do in order to support them in their transformation is not just welcome, but necessary, compulsory, mandatory. Among them, the legal assistance nowadays, in all the broadest sense, I think is necessary and welcome, because their lack of competence in all legal aspect, but also because I think that we need to have, I would say, a general ecosystem to be consolidated in order to save our companies in this very challenging period. One word, just one reference on energy. The energy commodity, I think, is one of the most long-term, not short-term, but long-term challenge that our companies will face. And they need to have all the assistance also on the legal basis and on the legal side, from the legal side, to be supported. And I would like also to mention that digital transition is also a challenge for liberal profession as such. And I'm not referring just to one particular thing that we are very strongly committed in stressing this point, and I refer first, artificial intelligence. Second, intellectual property. Third, the need to maintain the sovereignty of our data in the hands of companies, of European companies and European citizens. Is not granted at all. And we need to support all companies to maintain this kind of, let me say, let me call, sovereignty of their data. And no one better than legal professionals could act in order to do that. The ignorance, the lack of competencies need to establish a very strong ecosystem in order to support them in this particular area. As such, also for digitalization is important. I know that your president, Gaetano Stella, put forward a very interested opinion that we hope to resume and to rescue in the near future about the digitalization and liberal profession, the linkages between, because artificial intelligence could act as a very disruptive issue in the future. So, all in all, our feeling is we have not to be passive in this challenging period, not conservative, not protectionist, but proactive, and how to say, very available to adopt a new, let me say again, out-of-the-box mindset in order to carry on in the best way our professions in this case, or to manage our companies on the others. I'm really sorry because, as Stefano mentioned, we have to attend the bureau, the presidency bureau of the EC, and we have to leave this meeting. I wish you all the best for your work. Please, thank you so much, dear presidents. Thank you so much. Muchas gracias to everyone. dear Gaetano, see you soon. Gaetano is a delegate of the CCMI, so belonging to the Group 3 of this House. So, thank you so much and enjoy your meeting. Ciao Gaetano.
Good afternoon to all our participants. I am delighted to welcome you to this final event of the European Project Light. Special thanks to Mr. Palmieri, to the representatives of the European institutions, to the representatives of European lawyers and notaries, and their president, the notary Marcos. To the expert on AML, coming from academic and judicial world as well as from the enforcement authorities. After almost 2 years, we have reached the final Conference of Light, a project co-financed by the Justice Programma of the European Union that Professioni has promoted and has coordinated since December 2020. Professioni has always worked closely with the European Union, with office in Brussels for more than 15 years. 15 days ago, Professioni organized a mission to Brussels of 40 Italian professionals, including 18 presidents of our regional delegation, to know better European institutions. Thanks to our network and that of Federnotai, in 2020, during the pandemic, we began to lay the foundation of that has proved to be a solid partnership, which also includes the European Council of the Liberal Professions, the Spanish Bar Council, the Council of Spanish Notaries, and the Women Lawyers Association from Bulgaria, all represented at this table. Any legislation is only as good as its implementation, wrote President von der Leyen in letters sent to the Commissioner on December 1st, 2019. The Commission is committed to better application and enforcement of European legislation in the Union, and in this context, we hope that we have given a small contribution. Indeed, the work of legal practitioners play an essential role in guaranteeing and functioning European area of justice. And to this end, the training of legal professionals is the key. It is a fundamental tool for the correct and uniform application of European law in the Member States, for mutual trust in transnational process, and for the rule of law in the EU. Our project is based on these assumptions. It aims for the implementation of training activities for notaries and lawyers towards a better implementation of the European legislation on AML/CFT and better awareness of the role they can play in the field of anti-money laundering, which is one of the priority topics of the European law for training purpose. This discussion between the professions was useful considering the topic of the project, which is important but also extremely delicate. The project has achieved important results, involving notaries and lawyers from different European countries. Professioni has promoted the training involving the two different professional categories of notaries and lawyers, which are represented through Federnotai and ANF, respectively, to stimulate the European debate between different legal professions and to contribute to a European legal culture, which goes beyond the barriers between professions. For the future, I look forward to other opportunities of collaboration between legal professions. Now I leave the discussion of the projects to the speakers. I would also like to thank our team at Professioni, to my friend Enrico, to Anna, and in particular to Martina, who ensured a careful coordination of the project. Thanks again and have a good conference. Now I give the floor Miss Elka Poromiska, chairperson of the Association for Women Lawyers.
Thank you, Mr. President. Dear partners and colleagues, dear participants in the International Conference, The Role of Legal Professions in EU AML CFT, the final conference under the LIGHT project, Legal Competence Preventing AML CFT, Illuminating Black Corners. Ladies and gentlemen, on behalf of the Women Lawyers Association Bulgaria, which I represent, I have the honor to congratulate all partners in the project and all organizers of today's event, the Italian Confederation of Liberal Professions, professioni, the European Council of Liberal Professions, CEPLIS, the Italian Federation of Notaries Association, FederNotai, the International Union of Notaries, the Spanish General Council of Notaries, the General Council of Spanish Lawyers. The participation of professionals engaged in activities that are covered by professional secrecy, and specifically of the legal professions, notaries and lawyers, in the measures against money laundering and counter-financing of terrorism has been increasing in priority on the European agenda, and for this reason it's also a fundamental topic of the final conference of LIGHT project, which logically takes place in Brussels, the seat of the EU's main institutions. The future stability of the European security and the European institutions depends on the adoption of the adequate use of AML CFT, in which the legal professions have a paramount importance. It is necessary for AML CFT to reach the whole of Europe and every region for a unified European policy to be deployed and implemented. I believe that with the activities carried out within the LIGHT project, we have upgraded the foundation created by the normative regulations and conducted meaningful trainings that increase the competence of notaries and lawyers. For many of the project participants, I already have feedback that they are applying what they have learned in their daily practice. This will surely increase the effectiveness of AML CFT policy in the partner countries. The specific knowledge gained within the thematic seminars held in Rome, Sofia, Madrid and Brussels will help notaries and lawyers to gain experimental insight and knowledge in EU law on AML CFT, to improve their capacity in AML-FT risk assessments, so that they will be able more actively to perform their AML CFT reporting obligations and to better analyze business relationships subject to their everyday work. The collected good practices within and as a result of LIGHT project will contribute to the exchange and dissemination of AML CFT within the professional guilds of lawyers and notaries, and will encourage them to adopt the measures more actively and monitor their effective compliance in practice. Along the indisputable significance and importance of AML CFT, the implementation of these measures also brings challenges related to the correct and timely identification of the red flags and accurate and correct exercise for reporting obligations. Therefore, it is important to continue improving the competence and skills of the legal professions in this area, not least in terms of ethics in their work, which should be in the direction of affirming and respecting European values. I firmly believe that the combination of training and sharing of good practices will give the perspective of higher competence of the legal professions in matter of the correct application of EU AML CFT policies. I thank you, all of you colleagues, organizers, partners and participants in today's conference for giving importance to these priorities. I wish everyone fruitful discussions and many new ideas. Thank you for your attention.
Thank you, Ms. Elka Poromiska. And now I give the floor to Teodoro Kotrubas, Director General of CEPLIS.
Thank you, Mr. President. No, of course not.
Okay.
Non ho problema. Thank you, President. I am very happy to be here with you today and very happy that the European Council of the Liberal Professions had the opportunity to contribute to this very important project led by Professioni, which is not only a member of CEPLIS but holds the presidency of CEPLIS. You are also the president of CEPLIS, Dr. Stella. I'm very happy because we had the opportunity to work on a subject that is dear to me, since as a university professor I had in the past contributed in the context of the Center for European Policy Studies on studies on the reasons that lead persons to engage in terrorist activities. And obviously, for the liberal professions, who are the natural pillars of the rule of law and of a democratically organized society, working towards a transparent organization of economic activities within the single market, without any space for or any tolerance of money laundering and illegal business, most of all terrorism, is of the utmost importance. All the partners, they were named by my predecessors, the Association for Women Lawyers, Federal Notai, the International Union of Notaries, the General Council of Notaries, the General Council of Spanish Lawyers, and obviously Professioni, have worked, I think, in this project with enthusiasm, and I was very pleased to see so many new ideas on the table. I am persuaded that the works, the results of this project, are going to feed in the future decisions and actions of the European Commission. Obviously, we are concerned about the issue also because who says liberal professions says principles, ethical codes of conduct. And obviously, transparency, integrity, honesty are values that are in the core of the exercise of the liberal professions. And I am pleased to remind it once again, liberal professions are not only working for the pleasure of gain. The pleasure of the good work being done is more important to the liberal professions than gain. So I'm very glad that CEPLIS has contributed to this work. I wish you all a very fruitful meeting with new ideas on the table again. Thank you very, very much.
Floor to President Marcos at the last minute change in his flight schedule. And so I kindly ask to leave him the floor a bit sooner than expected.
Thank you very much, President. I'm sorry, but I have a big problem with my family. I need to anticipate my flight. Thank you very much to invite the CNU today to speak in front of you. The fight against money laundering and the financing of terrorism is a subject of major importance for the notaries of Europe, which I represent, and I believe I'm correct if I speak in general terms for all the legal professions. Notaries are particularly concerned to contribute to the fight against this scourge, not only as entities subject to anti-money laundering obligation, but also and above all because of their function as public officers appointed by the state. Notary contribute on a daily basis in preventing money laundering is important area of legal transactions. For example, in real estate and company law. The prevention of money laundering and terrorism financing is one of the key responsibilities of European notary. Because on the 4th AML directive, the role of notaries in fight against money laundering and terrorist financing has become ever more important. The 5th AML directive has further increased the notary's due diligence obligation. In most states, notaries are designated obligate entities under the national anti-money laundering laws, a role they perform with great responsibility and diligence. They identify all natural persons and beneficial owners of companies and other legal entities that participate directly or indirectly in real estate or company or corporate transactions. This is key for all customer due diligence obligations as well as the correctness and the reliability of the public register. This way, notary expose mere figureheads who act on behalf of somebody else and may be used to obfuscate ownership and control structures. Notaries act as gatekeepers for public registers like the land and the business registers. The fulfillment of this obligation is closely monitored by the supervisory authorities and no compliance may result in disciplinary sanctions. In addition, notaries are obliged to file a report of suspicion to the National Financial Intelligence Unit if certain criteria under national law are met. This way, notaries support the work of law enforcement agencies. Furthermore, notaries are obliged to check if a person involved in the transaction appears on an official financial sections list. Unfortunately, this is particularly important in the current context of the war in Ukraine, which has led EU states to adopt a series of sanctions measures against Russia and Belarus, and more recently in Iran. The CNU has sought to be involved in the Commission work in this area from the outset. I personally participated in the expert group of asset freezes and reporting set up by the Commission in order to ensure effective implementation of sanctions. However, not only the identification of beneficial owners is crucial in the fight against money laundering. Due to notary's excellent knowledge of business activity at their office location, they are also able to identify contract arrangements that could facilitate laundering money. While leaving the discussion of the specific content on the anti-money laundering package to the following panels, I nevertheless would like to recall in the current text context which specifies of the legal professional should be taken into account. Indeed, it has to be noted that the legislation in this area is often conceived with the financial sector in mind and does not take sufficient account of the other sector. However, unlike the financial sector, the non-financial sector is heterogeneous and has its own specificities, which is important to respect and maintain as they contribute to the effectiveness of the anti-money laundering system at the national level. What are the specified of the legal profession and notaries in particular? Notaries are partners of the state by reporting suspicion transaction. Legal practitioners need adequate protection. Legal practitioners' offices are often micro and small business and lack sufficient tools. supervision of notary is very, very important and very concerned. A strict and definitive monitoring regime is already in place at the national level by Minister of Justice. And for finish my intervention, the difference among the notarial system are significant between the different UE countries. Thank you for the floor. I am sorry, I apologize for the anticipation of my interview switch. Thank you.
Now let's go in with the agenda. Give the floor Edoardo Rinaldi, President of Federal Notai.
Dear partners, dear colleagues, Mr. Stella, dear speakers, European institutions, I would like to extend my greetings to you all. It has been an honor for Federal Notai, my association, to have participated in the LIGHT project and to take part in this final conference. In Italy, Federal Notai with professioni had a workshop in Rome from the 31st of March to the 1st of April. The heartfelt participation of institutions, legal professionals, made it possible to harmonize the procedures followed in the fight against money laundering and to take stock of the many aspects where improvement is needed. Astonishment was shared when it was noted that in few European countries the reporting of a suspicious transaction is not confidential and it's not covered by anonymity. It was then observed in analysis of cases that money laundering, like terrorism, now has an increasingly international matrix. It is therefore necessary to provide professionals with new tools, such as access to clear and valid databases shared throughout Europe. It has also been seen how money laundering occurs in procedures divided into different stages, and it is therefore seems essential to provide professionals with tools that enable the control and verification of complex activities. In this context, the Italian notaries' project of a data warehouse, analogous to the Spanish notaries, was welcomed. Data from notarial deeds are fed into an integrated database and enables the reporting of a suspicion transaction. It is therefore an objective analysis of cases that involves artificial intelligence, analysis of notarial deeds, and provide preventive alerts to professionals. It is a tool that is complementary to individual professional activity and it is powered by it. As it emerged from the meetings, also a subjective analysis is necessary. The meetings with the client, the concrete verification of attitudes and roles, the analysis of anomalous elements that may go unnoticed by computer analysis. These are aspects where professions always play a key role in the fight against money laundering. And in this field, the Italian notaries have been recognized as playing an important role as a guardian of economic public order. The Italian notary as a public official and expert jurist is a fundamental aid. In Italy, more than 90% of suspicion transaction reports from non-financial professionals come from notaries. Another delicate feature emerged in the sanctioning procedures against legal professionals. The AML statutory, European statutory, as the criterion of proportionality as a central requirement, and this criterion must also be reflected in the sanctioning rules. In some countries, the difference in organization between legal professionals and corporate financial operators has been taken into account. In others, sanctions applied have been identical, without taking into account, for example, the difference between banking institutions and individuals. Professionals are not banks. It is unfair to require the same organization. It is not requested by the law. This practice could lead to the professionals as a preventive measure to create unnecessary documentation to prove to the inspection authorities a fervent activity, even where it is not necessary, and to report whatever transaction he or she is called upon in order to avoid serious financial penalties that could jeopardize his or her activity. It is therefore necessary to harmonize sanctioning regulations by making them compliant and respectful to the European regulatory framework. Legal professionals, therefore, know their role and they are ready to perform it in a spirit of service and responsibility. However, greater recognition of the importance of the professions and their specific features is also needed from the institutions. Thank you.
Thank you, Eduardo Rinaldi. Give the floor Cristina Armella.
Thank you very much. I am Cristina Armella, the President of the International Union of Notaries, Dear President of the Section of Economic and Monetary Union and Economic and Social Cohesion, European Economic and Social Committee, representatives of the partner institutions of LIGHT project, representatives of the European Parliament and the European Commission, representatives of the CCB and NUE, experts from the 4 participant countries, and ladies and gentlemen. The International Union of Notaries is an international non-government organization since 1948. It has 91 member notaries represented by the National Council or Chambers of Notaries of 91 countries who share the same vision to the notary and the notarial profession. The notary is a public official exercising a public function delegated by the state under the professional regime. Their mission is to confer ethically to legal acts and businesses, controlling legality and providing due and impartial legal advice. Our union aims to promote, coordinate, and extend the function and activities of notaries worldwide. It assures dignity, impartiality, and independence of notaries to provide a better service to users and society in general. Its external policy is aimed at transmitting knowledge and sharing experiences with international organizations and governments. The aim of this cooperation is to provide the regulatory frameworks to affect citizens and businesses around the world, and the collaboration with the public authorities, which is also an essential part of the notary's function, as a public function, which must manifest itself in the assistance to those aspects in which it is required, such as the fight against money laundering and terrorist financing. In this sense, reorganizing the key role notaries have in the fight against these crimes since 2017. The Union has strengthened involvement in these matters and has been reorganized for this purpose through a creation of an ad hoc working group, and the request is of an expert in this field as a permanent and proactive contact with international organizations. She's here, is Capello, Mrs. Capello. Since then, strong links had been established with international organizations such as FATF, Gafilat, OAS, and the World Bank, taken part in several joint working groups, which include participation in the FATF Policy Development Group, responsible for the development of clarifying international anti-money laundering standards, in the development of the guidelines for the risk-based approach of legal professionals. Participation in the International Money Funds Working Group on the identification of the beneficial owners, whose objective was to identify existing models of centralization and access to information on beneficial owners. The development of the risk indicators document jointly with Gafilat that provides clear and precise guidelines to help notaries improve their analysis to notarial transactions, to enable them to detect transactions suspected to be linked to money laundering and terrorist financial. Within our organization, the AML working group has developed good practices in comparison of money laundering and terrorist financing in the notarial sector, which is a guide of methodology, system, tools, and techniques applied to facilitate the compliance with preventive measures in the notarial field and the harmonization of producers among our members. Guidelines to conduct the AML's risk assessment in the notarial sector, with the purpose of establishing the basis for the execution of such assessment, proposing minimum contents of elements and criteria to be considered in order to facilitate the self-regulatory bodies or each notarial council members of our union to carry out such assessment of the notarial sector in their country and its application to the sector as a whole. The third, a comparative database of the treatment of the prevention of money laundering and terrorist financial in the countries of the Union member notaries, with the purpose of knowing the current status of the regulation on the prevention of money laundering and terrorist financial. Another 8 online training courses which are published in our online training platform. The last key assistant projects aim and improve collaboration with legislators to promote the role of self-regulatory bodies as the signing of and agreeing with the Financial Investigation Unit of Bolivia. Currently working in the development of the document on risk and management of virtual assets, which would be discussed during the next meeting of our group to be held in Mexico next November. As a recognition of these efforts, the Union became the first non-governmental organization to be accepted as an observer in the group of experts of money laundering control of the Organization of American States, GELAVEX. In this context, it was a great satisfaction for us to be invited to participate in the LIGHT project, which aim and increase the legal competencies and ensure the effectiveness of AML CFT policy regarding lawyers and notaries in Belgium, Bulgaria, Italy, and Spain, particularly providing guidance and practical insight to help them recognize possible money laundering of terrorist financial operations and how to proceed in such cases. We believe the training received and the possibility for lawyers and notaries to exploit the cross-border nature of MLFT and to share a common vision and modus operandi in European Union, AML-CFT, jointly with the report on good practices for the lawyers and notaries, will certainly contribute to the improvement of the compliance level with AML-CFT obligations in these sectors. In summary, I guess we can be very satisfied with the results of the project, as I am convinced that with all the activities conducted during the project, we have greatly contributed to its initial objective, but always keeping in mind it is also essential to promote the continuous training of legal professionals, as well as their continuous updating on new trends and typologies related to these crimes. I would like to thank all the experts of the different partners who conducted the LIGHT project during these 2 years and congratulate them for the hard and great work they have done. Thank you.
Thank you, Ms. Armella. And now I give the floor to Mariano Garcia Fresno.
Sorry. On behalf of my president, Mr. Ángel Martínez Sanchís, president of the Council of the Notaries in Spain, I would like to thank and to give a welcome to the final conference of the LIGHT project. Okay? I am Mariano Garcia, head of the Analysis and Communication Unit of the Centralized Body for the Prevention of Money Laundering, OCP, of the General Council of the Notaries of Spain. First of all, I would like to thank those responsible for the project Light for having allowed me and my team to be part of it, giving us the opportunity to explore new avenues of cooperation and understanding with all the other participant organizations. I would also like to thank the collaboration and commitment of the members of the different work groups, as well as the management and coordination work carried out by Mrs. Martina Gerlenda and Mrs. Silvina Capello. The LIGHT project was born with the vocation of increasing the effectiveness of the European Union's anti-money laundering policies in the legal professionals, with the aim of achieving improvements in the deficiencies detected by the European Parliament and the European Commission. Today, after more than 2 years of work, I am firmly convinced that the necessary synergies have been created to achieve most of the proposed objectives. However, we must not and cannot be complacent about the work accomplished. The fight against money laundering and terrorist financing must continue. We must face the new challenge that arises building of the experience we have gained and using all the tools at our disposal. With people like you and with projects such as the one we are now working on, our work will be much more effective and we will certainly be closer to achieving all our goals. I am not a notary, I am not a lawyer, okay? But I've been working, fighting organized crime for the last 30 years with my friend Luis. I promise you, if we don't do anything, we have a problem. We have a problem. Organized crime always wants more and more money and more power. Thank you very much.
Oh, yes, thank you to the European authorities here. I am so glad and so honored to represent the Commission of Anti-Money Laundering of the Spanish lawyers, the General Council of Spanish Lawyers. I have been working for the government. I was a civil servant with Mariano in fighting against money laundering, and I have seen this fight also from public vision and from private vision. And I, of course, think that this is an important issue. This is a great project because the training is in the middle of the problem and it's very important to fight against AML. Thank you so to the European Economic and Social Committee for this support, so important for this project. And of course, congratulations to the professionals involved in this project, especially Martina, Silvina, and all the countries involved in this interesting project. Lawyers in Spain are improving the compliance. We have more and more STR, suspicion transaction reports, and we have a great conscious in the profession in Spain about these problems. But of course, we can improve this compliance, as we know. And really, we are progressively enhancing these questions. We have made important efforts, but we have to continue disseminating this formation, this training among Spanish lawyers and European lawyers in general. Of course, we need to make a great effort. We have to fight against powerful organizations. Of course, lawyers are professionals, are in the middle of the problem, of course. But we also need some support. We have some requests for the public institutions and we need some public measures to improve our compliance. We have now a change in the rule of the AML. We have the rule book. Just we think in the next year we have this book rule approved. But it's very important for lawyers, I think, to have the self-regulatory bodies in the countries of Europe. Not all the countries in Europe have these self-regulatory boards, and it's very important, as I think the notaries in Spain has demonstrated, with the OCP of the Spanish notaries. We have also to improve the public-private collaboration agreements. We have to make cheaper and easier to access to the information, even to the public information. Why can I not know where is my client working if I can check it in the Spanish labor registers, public registers? Why cannot confirm that my client has an account, a bank account, and if he's real the titular of this account, the holder of this account? Why don't improve the mechanisms to interchange information with the public authorities? This is I think this is a good place to say this and to request some help to improve our due diligence process. I think the regulatory package announced may help the Spanish lawyers and the European lawyers to improve the compliance. And I have to say that we have not a sufficient supervision in Spain. We have only 150 civil servants working in the FIU in Spain. We are 150,000 lawyers in Spain working. We need a better effort to supervise the compliance, and we need a FIU enforced with the personnel enough to effectively control the compliance. We need a better feedback from the FIU about our work, not a general evaluation, but what is happening with our reports. We need a feedback. We need to improve the dialogue between the FIUs and the General Council and the SRB, the regulatory for professionals. I expect that the new AMLA, the new agency, will be a interlocutor, will be a fluent way to interchange information with the lawyers. And we need legal mechanisms to share information with other lawyers, with other professionals, with other companies, of course always taking into account the rules of data protection. We expect that the new regulation bring great improvements in all these areas. For example, to regulate, to rule an adequate concept of fiduciary services more precisely than we have now. And okay, we will have some modifications important in this matter. For example, the prohibition of companies with bearer shares. I think is a very important question. And in general, the fight against anonymity with the now new package, I think, will be guaranteed. So let me also conclude that you must think that we have to always respect the professional secret, the privilege of the lawyers, but we have to comply with the rule of law. Thank you very much.
Thank you, Mr. Blanc. We received a brief address from the Director General of the Bulgarian National Radio, which contributed to the communication of the project activities. And Martina is going to read this speech. Thank you.
The letter is addressed to all the partners of the project. Dear ladies and gentlemen, please accept my sincere regards and admirations for organizing this very important and current forum, the final conference of the LIGHT project, which will see the presentation of the results of 2 years of work on the prevention of money laundering and financing of terrorism. In May 2022, the Women Lawyers Association and the Bulgarian National Radio signed a media partnership regarding the organization and coverage of an international training seminar in Bulgaria for lawyers and notaries from Bulgaria, Belgium, Italy and Spain. For us, this partnership is a honor. We feel that covering the results of the studies and practical experience in prevention of money laundering and financing of terrorism is very important for the Bulgarian society. I also appreciate the important role of media in financial crimes prevention, both in our country and internationally. Prevention of money laundering and financing of terrorism is a very current topic, not least because the measures are not well known and not used to the extent provided in the European and Bulgarian law. That is why it is a pleasure and a professional duty for us to be the only Bulgarian media which exclusively covers the event in Brussels. The experienced journalist from BNR, Mrs. Anelia Toroshanova, author and host of the legal program Law and Themis, has been following all meetings and events that are part of the LIGHT project coordinated by the Italian Confederation of Liberal Professions in partnership with the European Council of the Liberal Professions, the Italian Federation of Notary Associations, the International Union of Notaries, the Spanish General Council of the Notariat, and the General Council of Spanish Lawyers. Congratulations to the organizers and the best of luck to the participants in the final seminar of the LIGHT project. Signed, Milan Mitev, Director General.
Thank you, Martina. We planned the panel on the work of European institutions. We are pleased to have here Mr. Salazar Romero and Mrs. Dos Orit, Mr. Oritz. But unfortunately, Mr. Radev, member of the European Parliament and co-rapporteur on the proposal for a regulation regarding the anti-money laundering authority, could not join us. We sent us a brief message will be read by Martina another time. To you, Martina.
Distinguished guests, ladies and gentlemen, first, let me start by congratulating you for the efforts that have been made to increase lawyers' and notaries' competence on implementing the anti-money laundering and anti-terrorist financing policies. Second, I would like to present my gratitude for the kind invitation to take part in the final conference on the international project LIGHT, Legal Competency to Prevent AML CFT, Illuminating Black Corners. Unfortunately, due to a scheduling conflict connected to my commitments in the European Parliament, I will not be able to join you in person during the upcoming forum. However, I believe in our constructive partnership in the future, especially in my role as a co-rapporteur on the MLA regulation. I am convinced that we will have other opportunities to discuss the current state of the fight against money laundering, the prospects for its development and existing shortcomings. With the ambition to limit the current weaknesses in AML CFT, my colleagues and I in the European Parliament are working on the creation of a new European authority, which, together with national authorities, will become a key element of an integrated system for the supervision of AML CFT. I highly appreciate your support for the training of lawyers and notaries in order for them to become fully prepared for the cross-border challenges and emerging risks in combating money laundering and terrorist financing. I am convinced that our joint efforts in this area will contribute to the establishment of working mechanisms in the legal environment at a pan-European level, a key condition for financial integrity and security in the EU. I wish success to all national and international institutions and organizations that partner in the realization of the LIGHT project, as well as to the participants in the final conference. Have a great time and please use this forum to develop initiatives and to build legal competency and policy to combat money laundering and terrorist financing. Sincerely, Emil Radev, Member of the European Parliament.
Well, Thank you, Martina Gerlenda. Sorry, Martina. Martina Gerlenda. Now, I give the floor to João Antonio Salazar Romero.
Thank you very much. Good afternoon, everyone. I would like to be quite brief. This week, several things are going to happen regarding the proposal, the legislative proposal that the European Commission tabled past year. Today, there's a Council Working Party taking place. In that Council Working Party, the Czech presidency has already presented a draft compromise text regarding the rule book to be adopted, and well, we will know something more at the end of the day. But in this evening, we will see whether our optimistic approach to the situation is well founded or not. Some of the things that are going to happen this week is that we are continuing the debate with the co-legislators regarding the adoption of this package that was presented past year, and it could be very well the case, and I hope I'm not going to be totally wrong, that some kind of compromise and some kind of agreement is already found at the beginning of next year. So let's see whether it also goes on that direction. Another thing that's going to happen, I'm today the share of good news. The Commission Supranational Risk Assessment, which I have had the pleasure to coordinate in its second edition that was already adopted back in 2019, and also of its third edition, it's going to be formally adopted if everything goes on its rails this Thursday before 10 in the morning. So alongside the staff working document of the Commission on Public-Private Partnership is going to be published on that day. I can tell you that I have been, up to now, working with the colleagues in the communication unit presenting and preparing the press materials that are going to be presented with that supranational risk assessment, especially because I'm aware that the conclusions that we reached back in 2019 are one of the starting points of this light project. In this regard, I would like to mention that our conclusions this year, and first of all, I should have mentioned that the third edition of the supranational risk assessment was initially foreseen for 2021, but maybe you are aware of this COVID pandemic that we have been suffering during the last 2 years. It has completely derailed our contacts with stakeholders. But also, I cannot avoid confessing that our preparation and presentation of the legislative package past year has added on top to further derailing the whole process. So, well, with this 1 year delay, we have presented this supranational risk assessment, in which our conclusions are pretty much similar to the ones we already presented in the back in 2019. But there are some aspects that I would like to mention now, because are extremely important, have motivated the change of the risk analysis that we have already presented previously in some other areas, which are the effects of the COVID-19 pandemic, but also the effects of the Russian invasion of Ukraine. I foresee quite a lot of things changing from these two situations in our current times. So let's see what's going on, especially regarding everything that's surrounding beneficial ownership treatment, anonymity treatment, cell companies treatment, free zones, high value goods, and crypto assets. I think those are the most important areas in which our assessment is going to lead to a change in the legislative proposals. Just to finalize my intervention for the moment now, I would like to refer also to a project similar to this one that took place during 2020 and 2021, which was actually, I wouldn't like to misquote it, it was a project for the training of legal professionals. The project was developed by a consortium that was composed by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe under a service contract. And the aim of this project was the development and organization of training for lawyers on anti-money laundering and counter-terrorist financing rules at EU level. One of the main, if not the main deliverable under this project was the preparation of two manuals, a training for trainers and a training for lawyers and notaries, of course. I was waiting until yesterday in the evening just for receiving the translations into all official languages of those training materials. And I have, of course, been able, first moment this morning, to send the link to those training materials to the organizers who I have been promised will share these documents among you. So thank you very much for your attention, and I'm ready to participate in the debate later on. Thank you.
Thank you very much, Mr. Romero, for your speech. And then I give the floor to Mr. Dotz-Orrit. To you.
Yes, thank you. I have prepared a presentation. Okay, this is. Well, good afternoon for all. I thank you very much to the organizer for inviting me to this interesting conference for one very important issue. Well, yes. Well, in this slide the first slide is the four last opinions of the committee about money laundering and related crimes, especially tax crimes. No. In general, the committee has supported the European Commission AML CT legislative proposal in recent years. It had considered them in general as steps in the right direction, but clearly insufficient. In the four opinions, in the above mentioned, the committee made some 40 additional proposals, additional to the proposal of the Commission, for a more effective fight against money laundering. I think that the legislative package of July 2021 could partly remedy the major legislative and policy shortcomings, but full implementation is delayed to 2026. For me, this is a problem. And I have a doubt. Will the European Council respect the content of the first EU AML CF regulation and the creation and competence of the authority in the money laundering? I hope yes, but I am not sure really. Well, I am not here. Well, now what are some of the main proposals of the committee in the four mentioned opinions. One, for me, important is promote an European pact, political and social and civic, to effectively combat tax fraud, evasion and avoidance, and money laundering, to involve European institutions, political parties, social partners, civil society, professional bodies is very important in this kind of pact. Another, the creation of a civil society advisory body, perhaps within AMLI or under the European Commission and with the participation of the authority. No? The third proposal is the more competence and resources for the European Public Prosecutor's Office and Europol, and close coordination with the future authority. Really, I don't know how must I. Okay. Well, I think that it's necessary and specific legislation to prevent the illegal action of professional enablers, like some law firms, tax consultancy, etc., in the management of shell companies, following the OECD approach in the very important document approved by the Committee of Fiscal Affairs in November 2021 and by the government, by all the governments in 2021. But also the cooperation of professional regulatory or supervisory bodies in the fight against malpractice and possible criminal activities of professional enablers would be an interesting line of development of the pact I mentioned as the first point of the proposal. Well, I think it's necessary to establish a legal obligation on the part of professional enablers to identify the beneficial owners of shell companies and the transaction they carry out. This is in the 5 directive. Yes, it's in the 5 directive, but not really clear that the role in relation with the professional facilitators. I think also it is necessary implementing the legislative package or promote a specific legislation to money laundering channel outside the financial system. Very important. A market in works of art, high-value assets, in free ports, customs, special economic zones, special certain commercial or trade transaction in real estate investment, etc. Well, provide sufficient resources to the financial intelligence units and tax authority of the member state and connect and coordinate them. I think the harmonization of the legal treatment definition on penalties of the offenses related of money laundering. The money laundering crime is in this moment is already has a common definition, no? But not the related crimes. Well, this is, I think, I finished the. I don't know if you might, because this is no, well, here, no. Well, the list of the countries, the 2 lists, the list of the Commission about money laundering and the list of the Council about non-cooperative countries for tax purposes, it is necessary perhaps unify and or articulate, and all the real countries should to be in the list. And the countries that are in the list are really good, but there are other countries that should be in the list. Monitoring and, where appropriate, sanctioning of transactions that companies and individuals carry out with the country of the list. And finally, to include a chapter on cooperation against tax frauds and avoidance, anti-money laundering in the European Union Free Trade and Economic Association treaties. Well, this is our please, no, the one. No, this is one question. Here there is several members of the Council of the European lawyers. Really, this is the resume of the main part of the resolution December 2021. I say, the new proposal of the Commission for oversight by national authorities and supranational European body will erode the independence of the lawyers from government and other state actors, and finish will undermining lawyers' independence and the rule of law. So the proposal of the European Commission undermines the rule of law too much. Really, I don't agree absolutely with this position. This is for me, very strange and corporatist position of the Council of the European lawyer that don't understand well what is the proposal and the instrument to fight against money laundering and other economic crimes that undermine our confidence, undermine the resources of the state, undermine really the justice of our society. I cannot understand. Benjamin Rizzo and myself had a meeting in January of this year with the chair of the CCB about this question. And there is a very different position because the Council said us that our reference in our opinion about that some lawyer firm collaborate with the management of shell companies, collaborate with the anti-money laundering, and we remember Panama Papers, one lawyer firm, Mossack Fonseca, and the 14th lawyer firm of Paradise Papers. Well, it's true, but of course we are not against the lawyers. It's a minority, but very important minority. The consequence of this minority. By that, for me, this is a question that it is necessary to collaborate all. We should collaborate against money laundering. Well, quickly, because I think I'm not sure I have time, and a question. When all this begin to grow powerful, and in which political context? I say tax havens, anti-money, a great wave of money laundering. In 1819, when a globalization neoliberal model of the economy, free movement of capital without regulation. Also in the European Union, we have a single market. We have full freedom of movement of capital and goods. It's okay, I agree. But without fiscal common policy, without fiscal harmonization. This is the base of many problems. Of course, the consequence of the Washington Consensus of the 80s, now the things are different. Are different for the International Monetary Fund, for the OECD. This institution changed also. But the consequence is the deterioration of welfare states in some of Western post-industrial countries. There is a very important study of Thomas Piketty that shows that the historical way to the equality from 18th century stopped in 80s of the 20th century and reversed from 80 to 2020. In the income and in the health, in both aspects. There is an important consequence in parallel to the growing of tax havens and growing in the money laundering. This is it. This is a very interesting made home, no, but consequence. This is the growth of GDP per capita in the United States, no? 50, 50, 90, and 90, 20. With in the last years, in opposite to the ideological speech about with you reduce the taxes, the economy growth, no, this is different historically. The United States is half of the annual growth, average annual growth in these last 30 years. It's similar in growth of productivity. This is GDP per capita. And what is in the best moment of the economy, the marginal, average or maximum marginal personal income tax rate? 74. Do you think we can think how it's possible to say 74 of, and in the 50 with Eisenhower, Republican president, 90% for the people with income more than $1 million, 90. And now 30, with less taxes rates, how is the tax evasion, tax fraud? In the worst decade with 74% of average of maximum marginal personal income, 5% only, and now 30, 35. This is, for me, a very, very, very significant situation. Well, this is the bibliography, Zuckman, Saez, Piketty, de la Rosière, Toddler Wire, and OECD. Very important, the last reference of these three Danish economists in the Finance and Development Review of the International Monetary Fund say important conclusion. One of the conclusion is that, I'm finished in this moment, that by the shell companies throw 15 trillion of dollars every year. Half of 85% of this flow of capital of illegal capital or tax avoidance capital, not necessarily illegal all, no? 85% by shell companies in European countries, and $7.5 trillion by shell companies in two countries, Luxembourg and Netherlands. Well, conclusion, there has been in the developed countries since 80s a decrease in income and corporate tax rate that has coincided with a notable increase in tax fraud and avoidance, money laundering, and the proliferation of tax havens. This has been made possible and in part promoted by the tax avoidance and money laundering industry, professional labor through law fees, tax consultancy expanding in the same period in Europe, in the United States, in all the countries. The industry of tax avoidance and money laundering. And this is one industry that don't touch the European Commission proposal or legal initiative. And finally, I promise I conclude, that the neoliberal globalization model we have experienced has allowed the proliferation, growth, and strengthening of the criminal economy and its organization that use the same networks of shell companies to money laundering that other legal institutions, companies, or physical persons. Legal action against these economic and tax crimes has to be taken simultaneously at national, European, and international levels and target both the natural and legal persons who benefit from them and the professionals who run the shell companies. The consequence for me of not acting decisively against this scourge of the basis of ethical and civic democratic principles can be social and politically devastating. And we are beginning to see that in social and political demonstration of one social rage against, with very negative political expression in many cases. Thank you very much.
Thank you, Mr. Orit. Now I will let Director Kotrubas moderate the remaining part of the conference. I wish you a successful continuation. Thank you.
Thank you, President. So we are going now to have a panel which is going to discuss the new AML package and anti-money laundering authority, supervision for designated non-financial businesses and professions. We're going more specifically to listen to the view of European lawyers and notaries, and it is my privilege to kindly ask Claudio Cocusa, member of the Anti-Money Laundering Committee, Council of Bars and Law Societies of Europe, CCBE, to take the floor. Sir.
Thank you very much, Mr. Chairman, Mr. Kotrubas. It's a pleasure to be here with you today, to have the honor to represent more than 1 million lawyers throughout Europe. This is my honor, this is my privilege, and it is a burden to a certain extent. I salute, first of all, Mr. Kotrubas, your words when you introduced the works. You mentioned that we are, as professionals, champions of the rule of law. And this is what we do. We are gatekeepers. We are champions of the respect of the rule of law. We are not enablers. Mr. Orit, you have used a lot the word that we fear a bit, the word of professional enablers. We do not enable the breach of the law. We are respectful servants of the rule of law. This is what we are. Having said that, we are asked today as CCBE to represent the view of European lawyers on the AML package. And I will try the next 10, 12 minutes or so to give our view and propose some suggestions and offer some criticisms. Before I do that, I'd like, however, to give you a framework of what the CCBE has done in the fight of money laundering. CCBE has been and is a strong supporter of this fight since the beginning of the introduction of lawyers in with the second anti-money laundering directive. Just let me name a few things that we have done in the past. One has been, and I thank you for that, also mentioned by Mr. Blanco, Mr. Romero, I'm sorry, the manual for trainers and for lawyers, an effort of all bars throughout Europe
to find a module to disseminate information and also to detect suspicious transactions with specific red flags for lawyers. It's been a tremendous work that we have made. It's been recently disseminated, and it's been an effort of many, many months of ours. But of course, I cannot not mention also works we have done with the IBA and the ABA. We have produced a lawyer's guide to detect and prevent money laundering with more than 100 red flags, covering from difficulties in identification, beneficial ownership, complex schemes of anti-money laundering. Because, and we should not, and I would like you never to forget that we are abused and misused in this process. Clients come knock at our doors, the doors of the gatekeeper, and want to abuse our services. This is important. We have, of course, cooperated with FATF. FATF have produced a set of important books regarding risk-based approach, guidance for the legal profession. We've done that work, myself, the Italian Bar, the CCBE, and many, many contributors over the years. And so as institution, we are there in this fight with you. This is clear. Also, I'd like to submit to you that all lawyers are here in this fight with you, but for a very simple reason, that we were there fighting even before anti-money laundering legislation was adopted. We had Italian lawyers, Spanish lawyers, UK lawyers, Hungarian lawyers, the obligation of identify client, even before the legislation, identify clearly the client, meaning understand who's behind the shell. We had this before. Secondly, we have a clear indication in our code, which is the law for us, not to produce, not to assist clients if they have the intention to make wrongdoings. We had that before. Of course, we didn't have this suspicious transaction reporting. We didn't have to report the client. But we had to abstain from having the client carry out wrongdoings. We had that before. So are we concerned with these introductions? Are we concerned with these issues? Of course not. We have no fear. We have no fears because we were involved in this work as gatekeepers, not enablers, since the beginning of our being lawyers. It's in our DNA. Now, let me, before we give you what are the views are, let me tell you what are the values at stake here when we come to tell you what our views are. The values at stake here are just the one that were mentioning Mr. Dotsoris before. Independence of lawyers. Independence of bars. This is the one value which is at stake. It's a value which is of paramount importance for the proper functioning of the legal system, for a true rule of law, and in democratic societies. Let me just remind you that, I remember it to myself, as they say when we plead in court, that independence is not an abstract element. It's essential for a lawyer to work and to carry out properly the work. A lawyer cannot do properly assist the client and serve the right which is brought from the client into the system for protection if he's not independent. He cannot observe and be subject to the state. He cannot observe and be subject to big corporations or powers. He cannot even be subject to the client because he's true to respect the rule of law. And sometimes, very often, we say no to the clients. So independence is not an abstract element, is not a corporativist attitude, is the true voice of us being lawyers. So this is not me for saying that. It's the European Convention of Human Rights, Article 6, is the Charter of Fundamental Rights of the European Union, Article 47, is the Council, is the European Commission in its 2021 Rule of Law report, which says that legal professions play a fundamental role in ensuring the protection of fundamental rights, and that an effective justice system requires that lawyers be free to pursue their activities in advising and representing their clients, and bar association play an important role in helping to guarantee lawyers' independence and professional integrity. So, independence is not a vacuum concept, it's an important one, it's a pillar one. The second value I want to bring to your attention is the access to justice value. You will say, what is that? Well, there is no true and clear access to justice unless there is a full protection of the legal privilege of professional secrecy. We all know that professional secrecy has been affected by AML. We do know that. We have learned to cope with that. We understand and understood that our role at a certain point stops and our public function comes in and we have to report. It's not easy for lawyers, of course, but we have learned to pursue this goal with fairness and with correctness. But certainly, this value is an essential element in democratic societies. You do not go to a lawyer if you don't have full trust in him, and if you don't have full trust of this protection of your rights. If you've never been to a lawyer, and you might be, that you will go, you will want this protection. It's for you, not for us. The word corporativism looks like a club. We are not a club liking to play with independent values and with access to justice values, and we like to smoke cigars or drink whiskey. No, it's not that. It's very, very different. It's about you. It's about your rights. What rights will be defended properly if you find a non-independent lawyer on your footstep? What rights of yours will not be defended properly if the professional secrecy will be eroded further? So it's not about us. It's not about us. It's about you, about your families, about your rights, about your companies. So these are the two values. I will not cover the other legal passages where these values have been remarked, protected, and reassured. But coming to the view, we are of the view that the AML package affects independence. We don't like Article 38. We don't like Article 32. The CCBA does not support the introduction of a public authority oversight over self-regulatory bodies. States must not interfere with SRBs, with the state regulatory bodies, with independent lawyers' associations. We fear that erosion. We fear that passage. We would like to stop that. It's important, not because of ours being a club, but because of your rights. Also, Article 32 of AMLA, of the regulation, introduced the possibility to make individual decisions to SRBs in certain frameworks. We think there is, we need an exemption for bars, or a minimum, a change from a decision to a non-binding recommendation. We would like you to understand that the legal profession needs to remain independent from political interference, from public interference, from any powerful actors. And this value is important. Similarly, and I go towards my conclusion, we think that the package contains dangerous addictions and changes covering legal privilege and access to justice ultimately. In particular, Articles 17 and 51 of the regulation, which I don't want to bore you with the details, but alter the perimeter of legal privilege, and by introducing certain language to strict and shrink the exemptions granted to lawyers and notary publics when it comes to making the SDRs. We think that further shrinking that is a mistake. We think it's important that those principles remain untouched as they are. So I was given 15 minutes to give the position of the lawyers. I hope I was able to make it. I would like to conclude with the hope that that we will not follow Dick the Butcher's advice. And who's Dick the Butcher? Well, in King Henry VI, the masterpiece of Shakespeare, Dick the Butcher and Cade speak. And of course, we all know that passage. And Cade says, oh, I want to become the dictator. I want to fight the rebel. I want to have the power. I want to be number one. And Dick says, well, the first thing we do, let's kill all the lawyers. The first thing we do, let's kill all the lawyers. And of course, it's a symbol, this phrase, coming from the Shakespearean genius, that when the voice of lawyers, i.e. the voice of ours, of citizens, is limited, is hindered, things are not going in the right direction. So we are for this fight. We are with you with this fight strongly, but we hope that you will listen to the concerns of ours, and we therefore accept our proposal of changes. Thank you very much for your attention.
Thank you, sir. I don't think there is a person in this room who wouldn't agree that there cannot be democracy without independent lawyers. There are no independent lawyers in totalitarian countries. And so there is no person, I think, in this room that doesn't agree with the need for independent lawyers. What you said about the ethical principles being at the service of the customer is also very dear to me as Director General of CEPLIS, since a big part of our work is to uphold and to define and every time to update common ethical principles to all the legal professions. So thank you very much for this very interesting speech. I would like now to give the floor to Mr. Ignacio Gomalanthon, who is the chair of the working group on anti-money laundering of CNUE.
Thank you, Mr. Chairman. Authorities, participants, colleagues, Mr. Kokuch, I agree with you. We are not so many millions in Europe. We are just some thousands, some 100,000 people, notaries in Europe. But I agree with you that the Commission legislative package to combat money laundering and countering the financial of terrorism poses an enormous challenge for the legal professions. Money laundering is a postmodern, liquid, malleable, polymorphic crime, difficult to apprehend, difficult to detect, because its adaptability to different economic sectors, and because it is a seemingly second-rate crime which follows a much more visible antecedent crime, such as drug trafficking, for example, the results of which it seeks to conceal. But this does not mean that money laundering is a minor crime, something minor. It moves billions of euros that distort the market, establishing competitive advantages for those who break the law and, on the contrary, harm and disadvantages for those who comply with it. The liquid nature has given special characteristics to the fight against this crime, which are inspired by the FATF. recommendations. One of these is to impose certain obligations on certain professions which may be unwitting vehicles for money laundering, and to require them to adopt risk-based approach to money laundering in the exercise of their profession. These are the obliged entities on which we are one. There are two conclusions to be drawn for these ideas in my point of view, from my point of view. Firstly, we must all be aware of the importance of the fight against money laundering. The legislative package that includes directives and regulations shows us it is important. This implies, firstly, the need for training in the malleable and adaptive techniques of money laundering, which are not always obvious. Secondly, it imposes the obligations to get used to incorporating the risk-based approach into our professions as an additional function. Second conclusion is precisely because of its malleable and polymorphic nature, the response cannot be uniform in every country, in every profession, and perhaps within every profession in every country. Lawyers approach legal matters from a certain perspective, seeking the benefit for their client and effective legal protection, so that essential issues for them can be confidentiality and professional secrecy, or the secrecy of the communications they make to the FIUs, as well as a more clear determination of their obligations, not based on subjectivities, because it's something very difficult to assess. Notaries also have their own perspective.
It doesn't work, so we are passing the
Okay. No problem. Our own perspective. As the notary is a hybrid figure between a legal professional and a civil servant who participates in the function of the state and at the same time has to advise their clients. As a public official, the notary has a duty of impartiality towards citizens and have to take account of third parties, not just their clients, and he's also responsible for monitoring the legality of transactions. But they are classic gatekeepers. They detect obvious and clear irregularities, but it is not easy for them, for us, to uncover the hidden crimes behind the deals. They do not always have a good knowledge of the substance of the matter, which is sometimes very simple, nor their clients, who are often sporadic. Moreover, they do not contribute directly to the economical construction of the legal transaction, but rather to the final, formal or legal part of it. The notary's concern in this area is therefore the objective difficulty of discovering the underlying business with a very little information and with a more formal intervention. And our wish is to have clear and objective criteria for action as far as possible. On the other hand, it does not see confidentiality as a priority, given that our documents are public by definition. But whether we like it or not, whether it is easy or not, the obligations are there. And sometimes not only because of the money laundering regulations, but also because the notarial legislation itself, which has included this approach in the notary's own statutes. In my country, for example, since 2006, the Spanish notaries have had to ensure not only the formal regularity of the business, but also the material regularity. What does this mean, material regularity? It is a matter of ensuring not only that the act is apparently legal, but also that it is legal in its aims, in its true cause, in its intentions, and of avoiding that fiduciary, fraudulent, or simply illegal contracts. This is important to understand that the notarial attitude to the legal act has changed. To launder money means to answer questions, and to fight against money laundering is to ask the questions. However, it's very difficult to rest the whole fight against money laundering on the judgment of individual notary alone. Other means must be added. In my country, Spain, for example, is what the country knows better. In our country, the notary's judgment has been supplemented by the creation of a computerized index of all notarial transactions, the formation of a powerful database of beneficial owners, and the establishment of a centralized prevention body, a self-regulation body, which objectifies the indicators of money laundering, communicates with the FIU on behalf of the notaries, and exploits the computerized index by searching sequences and patterns beyond the notary's suspicions. Obviously, that is what the Spanish notary has done, depending on what it has considered appropriate for the functions of the Spanish notary and the specific risks of money laundering in Spain. Each country has its own different rules and notarial functions, more or less extensive, and different money laundering risks. But even so, we must be clear that the fight against money laundering requires a great deal of personal and material effort, but both individual and collective, and is strongly connected with technology and the handling of a mass information with large databases, all of which cost a lot of money. The Commission should take this into account. Nothing is free, and not all notaries are equivalent, either in functions or in economical power. In the working group, we have tried to find a common ground between all the needs and concerns of the different countries when drawing up the proposals for amendments, which is not always easy for the reasons mentioned above. Finally, I would like to say some specific aspects of these discussions and proposals. In the slide 3, we have beneficial ownership, and we have some questions. For example, the definition. As defined in the regulation, the beneficial owner shall be the natural person who controls directly or indirectly the corporate entity, either through an ownership interest or through control via other means. As suggested in most of the amendments, we agree beneficial ownership is based on two components, ownership and control. While these two factors might be fulfilled at the same time, they are essentially independent of one another. This makes necessary to reflect in the definition of Article 42 who owns, not only who controls. And it is crucial to include the meaning of all the possible situations which could determine the position of beneficial owner. A, direct ownership. B, indirect ownership. C, direct control. D, indirect control. And E, control via other means. Second question, threshold. In addition, recognizing that the concept of beneficial ownership is crucial to increase transparency of complex corporate structures and easy compliance with AML rules, as addressed also by multiple documents and current regulatory trends, we consider the threshold that serves as indication of ownership of a legal entity should be kept in 25%. In our opinion, reducing the threshold would not be adequate to achieve this purpose and could even be an obstacle for the identification of the beneficial owner depending on the structure of the company. Keeping this threshold would also be consistent with the FATF 40 recommendations, which, even after the recent modifications to the international standards aimed at increasing the knowledge of the beneficial owner by the obliged entities, continue to use the 25% threshold as an example of ownership of a legal entity or controlling ownership interest. Once defined, it should not be possible for the member states to adopt stricter rules as it would impede consistency among the member state rules. Verification of the identity of the question. The proposed regulation increases the due diligence obligations, mainly related to the verification of the identity of the beneficial owner. In our opinion, due diligence obligations must be proportionate, and the verification of the identity of the beneficial owner should be applied in a risk-based approach. This system ensures an efficient allocation of the resources and is also consistent with the spirit of the new regulation and the FATF standards. Another question is centralized information. We fully agree with the text of the proposed directive. In particular, it is recital 18, which underlines the fact that centralization of information on beneficial owners are essential to combat abuse of legal entities and is concerned to ensure the reporting entities can easily and quickly consult that information. However, we consider the centralization of such information is only effective if the information is in fact adequate and, above all, accurate and up to date. To this end, Member States shall ensure that verifications of the information reported by legal entities are thoroughly conducted, and it can be ensured the information is properly updated in a short and reasonable time. In addition, any barriers to access, including those of an economic nature, to the information would seem to run counter to this initial principle. In slide 4, we have considerations about the authority. First of all, the peer review committees. This new European authority for combating money laundering will be a key component of the AML package. According to Article 31, for the non-financial sector, the authority shall establish an ad hoc peer review committees, which shall be composed of staff from the authority and members of the non-financial supervisors. However, it would leave to the discretion of AMLA to involve representatives of self-regulatory bodies with supervisory functions on a case-by-case basis. The envisaged peer reviews will first form the necessary basis of a first objective assessment of the supervision. Second, significantly help improve supervisory best practices. And third, strengthen consistency and effectiveness in supervisory outcomes. In order to achieve that objective, we consider that the involvement of representatives of these self-regulatory bodies entrusted with supervisory functions in the peer reviews should be mandatory and not only discretional, as it would be inconsistent to include supervisory authorities who have delegated supervisory functions to self-regulatory bodies and not including those self-regulatory bodies' representatives. In addition, not all the non-financial sector is organized in self-regulatory bodies entrusted with supervisory functions. In these cases, representatives of obliged entities who indicate an interest to participate should be given the possibility to do so. This is all the more important because the peer review results will form the basis of this authority guidelines and recommendations pursuant to Article 33 regulation, which will not only be relevant for the national supervisors, but also for the obliged entities themselves directly. And finally, in relation to supervision of designated non-financial businesses and professions, even not being an assumption included in the original text proposed by the Commission, there are some amendments suggesting the possibility to provide the authority with the powers of direct supervision of selected obliged entities of the non-financial sectors. In our opinion, as the designated non-financial businesses and professions sector is so heterogeneous, the provision of this to the authority the powers of coordination and oversight supervisors, and the power to require the supervisors to investigate and possibly sanction these professions is sufficient, in our opinion, to bring this AML supervision to an efficient and uniform level across the Union in the sector. Thank you.
Excuse me, we must go to take a plane. Then we leave the meeting, yes? Bye-bye.
Bye. Thank you, sir, for presenting so clearly the views of CNUE. We really appreciate that speech. I have one request from the organizers, and this is not to forget to sign at the document that is outside. Sign is confirming that you were present, so the organizers would kindly ask you to do that. I am now pleased to present a roundtable discussion on the national situations. Unfortunately, I have just had word that Judge Michel Claes is not going to be with us. Something urgent, personal happened to him. So the three participants in this roundtable are going to be Mr. Alessandro Buttice, who is a former Brigadier General at the Guardia di Finanza and former head of unit at the European Commission, Dr. Todor Kolarov, who is head of the National and International Security Department of the new Bulgarian University, and Mr. Mariano Garcia Fresno, who is head of the Analysis and Reporting Unit of the OCP Spanish General Council of Notaries. So without any other delay, I pass the floor to Mr. Buttice.
I'm so sorry, Mr. Kutrovas. I see that Martina is not here, and neither Anna. From what as far as I know, Mr. Alessandro Buttice is not present and will not be attending the roundtable. So we will have the representatives of Todor Kolarov from Bulgaria and Mariano.
Then I would kindly ask you to take the floor.
Well, as you prefer, we have thought about doing questions for the debate instead of making presentations.
You can also chair the meeting.
No, at all. But I'm so sorry. I'm so sorry. I am here just informing what the format was that had been thought. But if you are not agree with that, we can.
I agree to everything.
We can do the things. Maybe Martina can explain this a little better. We're at the round table, Martina. And well, good afternoon to everyone. Sorry for this misunderstanding. There was a problem with some of the attendants, as you may see, and most of them are part of, or were part of the roundtable. So we had to adapt this in the very last minute. I think that for the benefit of Mr. Kolarov and Mr. Garcia Fresno, who I fully appreciate, are here to be part of the roundtable, and they had also been part of the project and trainers in the Bulgarian seminar. So I know I have the confidence with them to propose doing questions here, to raise a debate and to gather your opinions, and then making a final conclusions from each of them instead of making a stand-up presentation. If you fully agree, I think that that would be the best way. I'm going to introduce myself. I am Silvina Capello from the EU AML. I'm so sorry. If it's okay for you, I would like to start by asking, we have spoken today in most of the presentation about challenges. Challenges regarding not only the new AML package, but regarding the current challenges with the current regulation. Limiting the situation, of course, to your expertise, which is the legal professionals. I would like to start by asking your opinion in what do you think are the most important challenges in the current AML CFT framework for the legal professionals? I don't know who wants to start.
Thank you. I think that for both lawyers and notaries, one of the most important challenges they face in the fight against money laundering is the unification of the level, of the unification of criteria, of legislation, in guidelines, in behavior. Okay, I think there are many differences between a lawyer in Spain, a lawyer in Bulgaria, a lawyer in Italy, or a lawyer in Belgium, okay, or a notary, okay. Not only at European level, sometimes in the same country, sometimes in the same country. There are different, at least in notaries, there are different types of kinds of notaries in the same country. It's true, I promise you. Okay, and there are different competencies in notaries in different countries. Okay, I think that the first challenge is unification, at least at the minimum. Okay, obligation, guidelines. I think that this unification of criteria must be upwards, increasing these levels of compliance. Okay, and the second challenge, not only for notaries and lawyers, is obtaining information about the beneficial ownership. Okay, for me is the key in money laundering, anti-money laundering system. Okay, because when a lawyer or a notary have a company in front of them, they need to know who is behind this company, who is. And it's very difficult. It's very difficult. I think there have been different register or database in Europe, and we have to start to share information between all of us. As you know, in Spain, we have in notaries created 10 years ago a database, a specific database with information about beneficial ownership. And this database allows Spain obtain a good rate in latest FATF evaluation. But we have to work together to obtain information about beneficial ownership. For me, this criteria, unification of criteria levels and obtaining information about beneficial ownership are the challenge of this subject.
Thank you, Mr. Garcia.
Yes, if I may add to what the colleague mentioned, Mr. Garcia Fresno, of course, ultimate beneficial ownership is a very important matter. It comes as no surprise as it's a problem for the European lawyers, bearing into consideration that FATF actually amended its recommendation 24 in March of this year to strengthen this aspect of the anti-money laundering regime. So it's not idiosyncratic to lawyers and notaries. But if you allow me, I would also like to highlight another point in the regime, and maybe before doing that I should make a disclosure like Mr. Garcia Fresno did at the earlier stage, that in addition to being an associate professor in law, I'm also a practicing lawyer, so but had no actually a role in putting together the position of the lawyer, so please bear this into consideration. As we're presenting the results of this study which we did in the different countries, I think it's fair to say based on what criteria or what, so to say, methodology I'm presenting this view or this opinion to you. And the methodology that we used in Bulgaria, where we had primarily Bulgarian lawyers, I mean legal professionals, notaries and lawyers, but in addition to that we also had participants from Spain and Italy. Some of them I see here, and I'm glad to see them in this among the audience. We had actually 6 Italians and 7 Spaniards. So what we did is we presented 3 hypotheticals, and we submitted them to a mixed group of lawyers, notaries, lawyers only, and notaries only, and we just tried to see what are the results. So we did like a mini empirical analysis, and of course it has the limitations of being done among very few people. But it seems to me that the biggest challenge which I see, in addition to what Mr. Garcia Fresno said, of course, ultimate beneficial ownership, the most problematic matter for me and for the team, here we have also Dr. Yordanova, who was part of the, Gergana Yordanova, who was part of the training team. For us, one of the major issues is that more complex schemes, money laundering schemes, backed by judicial decisions or arbitral awards remain unnoticed by the lawyers, or if maybe unnoticed is not the correct word, but they're overlooked because it's a judicial decision and there is yes, res judicata, and you just have to go with it. And I have, of course, I've researched this matter previously, and I have a publication on this matter, but it also seems to coincide with some of the findings that colleagues from Sweden, particularly Haugesson and Mort, in 2018 did in their research of the challenges that lawyers in Sweden encounter, and those challenges were based on empirical analysis. So they as well pointed out that when we have such schemes, when we have such, when we have res judicata, then lawyers as gatekeepers are reluctant to actually address the matter. And we should not forget that the global laundromat or the Russian laundromat, the Moldovan scheme, whichever you want to call it, is a scheme which relies explicitly on that. It's debatable whether the arbitrators themselves have the competence to raise the matters of money laundering or corruption, for that matter, sua sponte, or their own account. I believe that's not the case, but it's of course my opinion. There are different opinions. I think this is one of the matters which sometimes is overlooked, and I believe that this is a matter which deserves more attention, maybe not only on EU level. In addition to that, I also would like to, if I'm not overstepping my bounds and my time, I would like also to kind of confirm what Mr. Dos Orit mentioned about these different databases and different lists. Let's not forget that in addition to the EU-wide list, we also have other lists. Well, of course, the FATF black and gray lists, but we also have lists that come from other jurisdictions like OFAC, which lawyers need to also be aware of, because otherwise they'll have problems. They cannot actually open an account for their clients in a bank. No bank would be willing to do that, at least not in my jurisdiction. So I think that these are some of the challenges that that are encountered, maybe on a more practical level.
Thank you very much. I am going to add another change, Mr. Chair. I'm so sorry. But you are doing the chair job, so I'm so sorry. I welcome Mr. Eduardo Rinaldi to join the roundtable. So, yeah, we would like to know your opinion about that. Thank you.
Hello again. I think the most important challenge that we face on a daily basis is to keep our independence. Because on one side we have a client who comes to our office, on the other side we have to analyze and investigate in some ways, as we are delegated from our state to do that, and we go in some ways in depth on what's analyzing the operation that we are called to look upon, and we have to keep our independence. We have to keep, in some ways, as notaries, we can not refuse to go on with our deed. We have operated on that, and we know that depends our office on our clients. So I think that keeping our independence is the key of everything. To keep independence, we need more training professionals. Then we need probably bigger firms, because independence means also economical independence from the clients who come to your offices. So one thing that in all European countries should be done is to promote the unions or more individuals professionals, to have lawyers firms bigger in order to have a more effective anti-money laundering inside each firm organization in order to accomplish the tasks that are asked on us. Another thing that has been called here, has been discussed on, but probably we don't stress it as much as it needed, are the tools that should be given to the professionals, to notaries and to lawyers. We are asked, especially in Italy, to do investigation on our clients, but we don't have access to the databases that the police have, that European and anti-money laundering authorities have. So for us, it's just guessing if the data that are given to us that are fed to us by our clients are right or wrong. If we make the wrong decision, then we are fined. And by fine, I mean that in Italy we are given 300,000 euro of fine, like as a bank. These are, of course, the fine is given, and it's good and it's fair if we face something. But the fine, in order to be effective, should be felt also proportional to the efficiency and to the task given to us. So I think it's we can't say that we should be fined as a bank who has a different organization and a bigger corporation. We should probably proportion the fine to the individual should be proportional to what we are called to do. So independence, training, better tools, as the money laundering is an activity more and more after the years international. We've seen with Russian citizens, but we've seen also in European countries. So in order to follow up and to see what the activity of the clients are doing, we have to access also a database from other countries, from other professionals to other notaries, and so on. And then, of course, also the principles, the regulatory fragmentation is asked. We have a lot of rules to apply. Our authority told us, the fiscal authority of Italy, that they just very proud of that. They said that they summarized the we say elements of discordance that that if we see them, then we know that the operation is at risk. And they summarized it and they said there are 360 of these elements that we have to see in each operation. I think that's enormous numbers of situations that we have to analyze in each one single operation. Then again, probably our authorities shall know when they have to do and relate with professionals, and when we have operation with banks or other institutions that can have inside their organization probably more people just doing and the analysis of anti-money laundering operations.
Thank you very much for joining the roundtable and for your answer to this question. We have heard today, we had good news and not so good news from Mr. Salazar regarding the supranational risk assessment and the results of the supranational risk assessment compared with the results of 2019, which seems, unfortunately but not unexpectedly, so different from the results of 2019 regarding legal professionals, or regarding the situation. My question for the three members of the round table, and anyone could start, whoever you prefer, is you have mentioned all the challenges, considering which is the level of compliance or implementation of the AML and CFT rules within the countries and in the legal professions. How do you think that we can ensure an effective implementation? What is necessary to be done from the regulatory perspective or from the professional's perspective to ensure an effective implementation of the AML and CFT rules?
Maybe we can rotate this time to make it more interesting. Yeah. Okay, so I would say that there should be a clear understanding that the legal profession should not be overwhelmed with responsibilities which are not feasible for the legal profession to execute. And actually taking up from what Mr. Rinaldi said, Mr. Rinaldi mentioned that maybe it's a better idea to encourage bigger law firms, because then they can execute the tasks. But I think it's a demand-driven, it's a supply-driven operation rather than demand-driven. I think we should be aware that there are different. We should not limit the number of lawyers that could enter the legal profession, and we should be aware that there are different companies. Some are big companies; they have more resources, but others are solo practices. And I think we should also be aware of that, and the legislator should be aware of that. And that's my view on that. That the legal, there shouldn't be, so to say, barriers to the legal profession which are not typical or idiosyncratic to the legal profession. We should not raise more barriers. I think this is important to have reasonable expectations from lawyers. That's my view. Thank you.
Thank you very much.
Okay, I think one a good solution would be a self-regulatory body. Okay, as you know, I've been working for Spanish notaries for the last 16 years in centralized prevention body, okay, OCP, but it's not necessary to have a specific or unit to analyze operations. Only with unified criteria, unified guidelines, unified to have a phone to call if you have a problem. I think councils, organization must do more than now, okay? Because between the FIUs, between the supervisor, a self-regulatory body is important for the lawyers and for the notaries. Okay, it's my opinion. And in Spain, Spanish lawyers has been trying to make a specific unit in money laundering. I wish they achieve their goal, okay? Because from my point of view, it's a good solution. It's a good solution to be in the middle between FIUs and supervisor and the legal profession.
The thing is, the key and one of the criteria of all the European regulation is that the proportion of the gates according to professionals who has it, according to its structures, and this, I speak of Italy because I know, of course, better my country than others, this is not respected at all by our authorities. As I told you, they ask you to see in each operation the presence of 360 different index of anomality, and if you fail to signalize them, then you are fined. I think this is a bit out of control. So back again, the proportionality, and so I do agree with Mr. Kolarov, should be again one key of the application also of the rules in each single country. Then again, the supervisory boards and the action of supervisory board is very important because the professionals can't be let themselves alone in this fight against anti-money laundering. And again, for each profession, probably the rules shall be the same, but lawyers are different from notaries. So probably the appliance of the rules in our profession should be different at one to the notaries, to the lawyers. But again, we have the same fight, so we need that shall be recognized our role, should be recognized our differences amongst us and the finance corporations, and we should be provided with more tools in order to perform the tasks that are asked by the European legislation. But if I see in the future, let's say 20, 30 years, I think, especially in Italy, the state will be more light and it will delegate a lot of its tasks to professionals. So again, in the future, probably, we shall have a better organizations. And again, the firms shall be bigger and bigger. That's the direction we are going. The direction is delegation of powers to individuals that are for that given a task to accomplish. And the notaries are ready to do that. Lawyers, I'm sure, are ready to do that. But we need also the authorities look at us in another way. We are in the same side with them. We are not against them. So we have to be treated like that. Thank you.
Thank you very much. I think that we do not have, or we have time for one more question, Martina. Okay. So my question is about the new. We have discussed the new AML package, and some of the reasons for this, for the development of this new AML package. Some of the reasons were regulatory fragmentation, a tick-the-box approach, deficiencies in supervision were among the biggest impediments, according to the fundamentals, to an effective implementation of the AML regulatory framework. My question is, do you consider that is compliance on its own enough to effectively stand up to criminals, or do we have to do, as countries and as professionals, something else? Just with compliance with and being efficient in the application of the AML rules would be enough? Yes, I'll try. I said that some of the reasons to consider this new development the development of this AML new package where things like regulatory fragmentation, tick-the-box approach, deficiencies in supervision was one of the main reasons for the creation of the new authority. So this was identified as the biggest impediments to an effective and efficient AML and CFT policy. The new developments are intended to deal with these issues with the creation of the AMLA, the new authority, and the new regulation and the new directive is trying to tackle these deficiencies that have been identified. My question is, do you think that compliance of these AML policies on its own is enough to effectively stand up to criminals? Does it mean that if we are able and capable of complying with these AML policies and CFT policies, it would be enough?
Thank you very much, sorry. Okay, I think we are one step behind the criminals, always, or two, or three, okay? I've been working, as I said, for 30 years, fighting against organized crime, and it's difficult to fight with them. It's very difficult. And economic crime is very difficult to follow, to fight, okay? It's very difficult. There are no clues, no blood, no fingerprints. It's difficult. It's difficult. Okay, we try to be more proactive. Okay, if we wait for the organized crime, we don't beat the game. Okay, sorry. Thank you.
Well, I absolutely agree with Mr. Garcia Fresno, law enforcement and everybody who's working especially in economic crime, countering economic crimes and organized crime, money laundering, they're always behind the criminals. So I don't see it as a silver bullet. But on the other hand, I think it's very important how it's going to be implemented. It's my firm belief that, and from what we heard, first of all, from Mr. Salazar Romero, if I'm not mistaken, it's still a question of a compromise, and we're still waiting to see what the final package will be. Yes, so we don't know for sure. We do not know for sure. But let's hope that this final package will be aiming at not at the low-hanging fruits, and will be implemented aiming at really the big fish, because then the systemic effect is much stronger. Then basically there is a ripple effect down the system, that others that are of lower importance, criminals of lower importance, will think twice before taking the steps. I mean, it's because sometimes the measures that we take collectively are aimed at those that are easy to catch, the low-hanging fruit, not at the bigger launderers. And that's my view. Thank you.
I think that is the point. We are going to a more complex society. Also, the criminals are going more complex. The criminals don't go around with the gun, especially in this crime. They have a tie, so you can't really recognize them. That's why it's very important that with this subjective, let's say, subjective gate given by individuals that daily basis meet with clients physically, should be also what the Spanish friends have already organized, an objective database that will connect to artificial intelligence all the dots in order to see the bigger picture. The thing is that the bigger picture will be only in Spain. So if the crime starts in Italy, then go to Spain, and then back to Germany, then we have to connect also these three countries. And that's why European Union should step in, probably with the authority that will come on and help us in order to also purchase and go after bigger operations.
So thank you very much, the three of you, especially for the the summary in the responses, given the time, and in order to end on the due time. I think that we have finished this roundtable. I will leave the floor in case anyone wants to ask one final question, and if not, we move to the next panel.
Just about the last thing, don't you think that the access or forcing the liberal professionals to interfere with that database will give a major responsibility to liberal professionals, just like I don't know, policemen or officials, like state officials, like those?
Well, of course, it's a bigger responsibility, but that's what we are asked to do, especially as a gatekeeper, as it has been said, of the law. Then you gain more responsibility, and we are ready to do that, and we will be trained to do that. We are already been trained to do that.
Well, thank you, the three of you, for participating, mainly those that have joined in the very last meeting. Thank you, Mr. Rinaldi.
So let's continue with the agenda and on the project and project results. So it's a pleasure from my side to have the opportunity to say a few words on the project after so much work trying to ensure its proper implementation, almost 2 years. So I'll provide a brief introduction to the project Light, while I leave the floor to Ms. Capello for a more detailed analysis. As Professioni, among others, we aim at coordinating and promoting research and training activities addressed to our member associations and to liberal professions at large. In this case, we decided to target lawyers and notaries, which we represent through Federnotai and ANF, and we pursued the aim to strengthen the competency of lawyers and notaries on AML CFT. Therefore improving the effectiveness of EU law in the field of AML CFT. The decision to follow this topic lies in the Commission staff working document on the report on the assessment of the risk of money laundering and terrorist financing affecting the internal market and relating to cross-border activities. Indeed, this report stressed a certain vulnerability of liberal professions to money laundering, even if there are many differences among professions. And at the same time, the remote doesn't work. Thank you. As you may know, our consortium is composed by 7 partners in 4 countries, Spain, Italy, Belgium, and Bulgaria. And here, our decision was to mix countries whose practices could serve as good examples and others which may need more help in the implementation of European directives. And so our project is funded by the EU budget line on judicial training under the previous EU budget, which ran from 2014 to 2020. So clearly, training activities are the core of our project. Against all this background, we designed this structure you can see here. And at first, we organized 4 focus groups at national level in Italy, Belgium, Bulgaria, and Spain. The outcome of these focus groups was a report assessing the implementation of European law at national level. Afterwards, we drafted a policy statement on the role of legal professions in EU AML CFT, and at the same time we started preparing the coming training activities. These activities were composed by first an online training course. It was 8 hours long, and it was composed by presentations, videos, and exercises. Then we organized 4 transnational seminars, each in a different country, and each seminar was 2 days long. And we had the first seminar in Italy at the end of March 2022, the second one in Belgium in the end of April, the third one in Sofia in May 2022, and the final and fourth one in Madrid in June 2022. And each seminar was focused on a different topic, from reducing red tape to mitigating vulnerabilities, to questioning red flags, to identify new crypto crimes. So professionals had the opportunity to follow more the seminars, but they were not forced to, which may have been perceived as an excessive engagement, which may have discouraged their participation. And so the training part was the core of the project, and it was very rewarding but also very challenging. For instance, because of the remaining COVID-19 restrictions we had to face at the beginning of the year, when we had to organize the first seminar in Italy, which was later postponed by a couple of months. And this training phase will be complemented by a study visit to Europol, which will be organized next month. And thanks to the 4 seminars, we gathered some best practices, which have been recently translated into a report, thanks to the work of the General Council of Spanish Notaries and to Ms. Capello. And the report has just been completed last week, and it will be soon published on our website, so you will soon be able to read it there. Finally, today, the final conference, we're aiming not only at presenting the results of the project, what we have done so far, but also trying to launch a training initiative at national level and fostering the debate between experts and practitioners on various legal and policy issues. The final task of our project is an action plan on national training initiatives on this field, and we're going to finalize it shortly. So all this has been complemented by communication dissemination activities on our website, the project website, which you can see here, on the websites of the partners, and social media accounts, on newsletters, and any other usual channel used by the partners. So through all this, we tried not only to have an impact on the increase of competency of legal professions, but also in the longer term, thanks to the policy statement, to the multiplier effect of the national training activities, and to the collection of best practices, which may serve as a useful base for future action. So all these should ensure lasting effect also after the end of the project, and try to ensure its sustainability in the coming years. That was all from my side, and I will leave the floor to Silvina.
Thank you, Martina. My colleague Martina has focused on the structure of the project. I will focus in which are the contents of what we did. She mentioned the activities, and I'm going to explain briefly what you can find in each of the documents or each of the presentations, which are the deliverables that the project has. Does it work? No. Okay. So as Martina said, and I'm not going to stop here, we have different phases in order to design the training according to the needs identified, specifically for the lawyers and for the notaries of the 4 participant countries. So we started the project by coordinating 4 focus groups, 1 in each of the countries, integrated by lawyers and notaries, 5 and 5. We did it through video conference because we started this in the middle of the pandemic appeared in the middle of the project. So we had the focus group virtually. And the idea of the focus group, Anna, could you please? The idea of the focus groups was to gather the opinion of the professionals regarding the national framework to combat money laundering and terrorist financing. For collecting the information, the legal information, we prepared the questionnaire with questions in order to know how the system worked within each of the countries. But the focus group were focusing debates and roundtables just like we did today. What do you think? What could be done better in order to improve the compliance in your country? With that information and with the legal information, we prepare the assessments that Martina mentioned on the level of compliance of each of the professions in the 4 member countries regarding the EU AML and CFT regulations. Based on that, Anna, next one. Thank you. Based on that, we started preparing the training contents. And the first content, the general content, was the online training. As Martina said, the online training, it's an 8-hour videos training with a short exam at the end of each of the videos. So whoever wanted to participate in the face-to-face seminars had to complete these 8 hours of training. We considered, based on the results of the assessment and in the results of the focus group, that in order to make a uniform knowledge as a basis for the face-to-face seminar, we had to prepare the training based on international bodies and mutual evaluations, which are the obligations applicable to notaries and lawyers, which are the differences in the system. Terrorist financing, we consider that terrorist financing is the great forgotten. When we speak about AML and CFT, we tend to give training on anti-money laundering. We speak about criminal organizations. We speak a lot about which are the trends and the indicators in money laundering, and we forget about terrorist financing. So we prepared one of the basic training in terrorist financing, focus and based on what we said also today. We prepared a training in the identification of beneficial owner, which are the difficulties in the identification of beneficial owners that notaries and lawyers may face in the provision of their services. Risk indicators specific for notaries and specific for lawyers, not general risk indicators which are based mainly not only in the characteristic of the participants in the transactions, but in the provision of services, depending on the risk of this, which is the risk of the services that notaries and lawyers provide, and which are the risk indicators that could be useful for them to identify and to detect suspicious transactions. We prepared another course based on investigation of anti-money laundering and money laundering and terrorist financing offenses, because we consider that it was useful also for the professionals to know what happens with the information they report to the FIUs when they detect and when they comply with this obligation of detecting and reporting, how they can end in an investigation, and how those investigations, in which of the information they provide could be useful for the investigations of money laundering and terrorist financing. Then we focus on the specifically money laundering and terrorist financing risk in the legal professionals, because one of the conclusions, as we are going to see at the end, we got from the focus group and it is reflected in the assessment, is the lack of awareness of the risk and the vulnerabilities for the legal professionals sometimes. So how to identify those risks and how to apply the risk-based approach is one of the most challenging obligations of the regulation. And lastly, supervision of the legal professions, what to expect when they are supervised. And of course, how the supervision should be adapted considering the characteristics of the lawyers and the notaries, and not applying the same criteria for supervising financial institutions to supervise legal professionals. So we consider that these 8 elements, or these 8 topics, were the basis for the training in order to be capable, if you allow me to say so, to assist, or to be ready to assist to the face-to-face seminars. Anna, please. Thank you. I'm so sorry, Anna. Then we got, no. I know that you want me to finish, but I still have a few minutes.
No, we're thanks to Anna.
Then, in order to give uniformity to the 4 face-to-face seminars in terms of what to expect from the seminars and how to prepare the seminars, we conducted training of trainers. We have 3 sessions for training of trainers. 2 of the trainers, if I'm not wrong, are here. I'm sorry if someone else is present, but the 2 Bulgarian trainers are present here, so thank you very much. The trainers were selected on the proposal of the participant countries. The interesting part is that they have very different profiles, because we have academics, we had notaries, we had lawyers, but we also had law enforcement agents. So the scope or the expertise was much broader than if we only had academics or legal professionals. So that was the criteria we followed when we selected the participants, and that was the criteria we asked the participant countries to take into account when proposing these trainers. And what did we do in this training of trainers? We applied a 3-step approach, a briefing on what the seminar was expected to be, the format, the presentations, the preparation of a practical case by the trainers, but also it was part of the project to give the trainers minimum content of the training. So we prepare the content, where the General Council of Notaries prepare the minimum content to be considered when developing each of the 4 seminars. Anna, please. The face-to-face seminars, as Martina said, I'm not going to stop here, because as Martina said, were related to very different issues. On the slides you have which were the things that were considered and debated during the face-to-face seminars. We started by the AML and CFT architecture and what is the role of the legal professionals. Then we moved to the EU risk assessment methodology, because it was important for the legal professionals to know how this risk assessment is conducted and what is the methodology that the European Union uses, and also the FATF guidelines for the legal professionals. Then the 3rd seminar was based in customer due diligence obligations mostly, and also in reporting obligations, mainly to go in depth in the know your customer, the due diligence, how the beneficial ownership, and of course record keeping and reporting obligations. And the last one was based on virtual currencies with the aim of identifying new crypto crimes, but mainly focus in understanding and being aware of which are the characteristics of the virtual currencies, how they work, and in which situations lawyers and notaries may face virtual currencies and where, in the provision of which services they may appear, and what to do in those cases in order to reinforce the due diligence when virtual currencies is used as a means of payment or in the provision of any other service. And with all this, with the conclusions of the seminars and based on the expertise of the drafters of the reports, we prepared the report on good practices, on how to reduce red tape, how to mitigate vulnerabilities, question red flags, and how to deal with virtual assets, considering the risk of these new emerging assets. And, of course, this is not a document, a unique document. This is a guidance. This is intended to be a guide on the best practices we have found in order to deal with the deficiencies or weaknesses that have been identified through the assessment report in the focus group and also in the face-to-face seminars. So it's not unique, of course. I'm sure that it can be better improved, but I think it's a good document. As Martina said, it's going to be published in a few days. And I finish with this. Which are the main conclusions and which are the best practices based on? First of all, as most of the participants said, there are different approaches for regulating the legal professionals, not only in the different member states, but within member states among the professions. It's different, the system that we found in place and the policies and procedures adopted by lawyers than the policies adopted by notaries, even in the same member country, which is quite logical because, as Mr. Rinaldo said, it's not the same lawyers and notaries, but in some of the cases, the differences are even among professionals in the same sector. So same professionals apply different policies and different procedures, even in the same country. And this lack of uniformity makes it difficult to implement the rules, the AML rules. The second main conclusion, to deal with the first, as some of the participants have suggested, of course, making or giving uniformity to the rules and procedures, not among all the legal professions, but for each of the legal professionals, for lawyers and for notaries, having common procedures, common policies, can and is useful to improve the compliance with the AML rules. If all the professionals have the same rules for the customers, it will not be a decision on I'm going to another notary, I'm going to another lawyer because you ask so much or because the other one does not ask anything. And it's going to be easier for all of them to apply those rules. The level of expertise and compliance differ among member countries and among the legal professionals. We have heard here in the roundtable that some countries have developed and have created different bodies, different organizations. In the case of Spain, in the case of the notaries of Spain, they have a specific body for analyzing suspicious transactions, for giving uniformity to the regulation, to resolve doubts from the notaries, to report suspicious transactions. So the different the level of compliance and the level of involvement differs among the member countries and among the professionals. Difficulties, to identify, to assess, and understand the vulnerabilities by the legal professionals, and which makes difficult to implement a risk-based approach. In this case, what we have not discovered, but what we have confirmed is that the identification or the awareness of the risk exposure is not uniform, and in most of the cases is not even present. So when it does not happen, it's difficult to apply a risk-based approach. How to deal with this, or how countries, some of the countries have dealt with this, by doing the risk assessment of the sectors by the self-regulatory bodies, with, in some cases, the cooperation of the FIUs. There are some countries where the risk of the sector has been assessed by the self-regulatory body, but in or jointly with the FIUs, which gives it a different view on the risk. It makes much easier to apply a risk approach or to develop policies and procedures to comply with the AML regulation if we know which are the risks and we know which should we focus the enhanced diligence according to the risk. Challenges in the identification of the beneficial owner. Fortunately, with the new AML package, and if, as Mr. Gomez says, we can ensure that the information on the central or the centralized information is accurate, but mainly it is adequate and it is up to date, I think that this challenge will be reduced. But in order to do so, I think that we need to give a previous step, which is ensuring that information which is centralized on the about the beneficial ownership is accurate, has been verified, and is updated. Because in some of the registers, we know that there is a delay of 1 year in the information update. So if that is ensured, so this challenge could be reduced. Low numbers of suspicious transaction reports. Most of the countries, with some exceptions, in most of the countries, the legal professionals, and mainly in the case of the lawyer sectors, the number of suspicious transaction reports remains very low. In this case, some of the suggestions or the best practice have already been mentioned. Mr. Garcia mentions having a self-regulatory body, not necessarily a specific unit. Some other of the participants mentions the possibility or adopting measures to deal with the independence or this problem of independence between reporting or not, I will not say protecting, or being trustful with the customer. In most of the cases, it is based, and it requires also the involvement of the self-regulatory bodies. Countries where the most efficient level of experience are those where the self-regulatory body has been involved in the development of risk indicators specific for lawyers and specific for notaries. We have seen, not only in these 4 participant countries, but we have seen that in most of the countries, the risk indicators are general indicators. Indicators related to the customers, indicators related, but not indicators related to the service, which is what makes the distinction between risk indicators specifically for notaries and indicators specifically for lawyers. Not even the same indicators can be applied for both. In some cases, some of the indicators can be common, but not all of them can be applied for both. So involvement of the self-regulatory bodies in the development of the risk indicators. Insufficient training at national level. I think that the word training is the one that have most appeared during this, and it's logical, this is a training project, but the lack of training or the need for continuous training on the new trends, the new typologies, not only the new regulation is also required. In this case, again, you will see that we trust in the self-regulatory bodies, but not only the self-regulatory bodies. We consider that the competent authorities should help on this, on providing more training for and projects like this, and also the replication of projects like this at a national level can be a good tool. The need for guides and feedback from the competent authorities. I heard Mr. Ruby Blanc saying in the welcome speech that they require this feedback from the FIU and from the competent authorities, not only the feedback on what happened with the suspicious transactions they have reported, but feedback on you are doing well or not. You have to improve on this, or you could do it better. So I think that is another of the issues that can be improved. And as I said at the beginning, the unawareness of the risk of the virtual assets. I think that in most of the professionals, what we have seen is that they are not aware of the risk, but then they are not, as most of this or many of the society, they do not know how the virtual assets work, what you can do with virtual assets, and which are the characteristics of virtual assets. So it's welcome the inclusion of the virtual assets in a full definition in the new package. But I think that in order to deal with this, of course, we have to consider the need for training also on these matters. Thank you very much. And of course, we are at your disposal in case you have any doubt on the project.
I see it's self-managing. How do you say that in English? That you autogestion in French, self-management in English, at the end of the conference. I have the worst job. Everyone is asleep. It's a warm room. And I'm supposed to conclude. And I have 2 minutes. So, will the PowerPoints be sent to the participants? Will the PowerPoint presentations be sent to the participants?
Yes.
Thanks. I even wake up the organizers. So I think it's the end. Why am I here? And why was I asked to take the floor at the end? Well, I'm the training part, actually, from the European Commission. I manage the team who takes care of the European judicial training policy. So what's that? Training of justice professionals on EU law. Do you remember, even the non-lawyers among you, the expression guardian of the treaties? Yeah. So the Commission is the guardian of the treaties. And we do not only want to go with infringement cases against the member states, because that's like the nuclear weapon, the last resort that you use when you are facing difficulties of application of EU law. We try all prevention measures that we can ahead before that. And training of legal practitioners is one of those tools. If lawyers, notaries, judges, prosecutors, but also court staff, prosecution office staff, and even the ones who are afterwards in the chain, the bailiffs, the enforcers, are well trained, they will help us. They will help us that it is well applied everywhere. It's actually a national competence, training. Don't even try to use my PowerPoint. I'm not following it, It will be sent to the participants. I tell you, even the organizers are asleep at the end of this afternoon. It's really interesting, but it's warm in the room, and we didn't have any break. Yeah, in the training world, you could have had a break. So it's a national competence training. It's either we are in the field of judicial independence as well, even when we talk about training. So it is self-regulated for the professions such as the lawyers and notaries, or it is the judicial training institutions for the judges and for the prosecutors, or etc. So where do we come in? As support at the EU level. And we do have actually an additional competence, not just Article 7 of the Treaty on the European Union, which says that we are the guardian of the treaties. We have a specific competence to support training in judicial cooperation in civil and criminal matters. And there, that's what enables us not only to work with the professions, because we work very well with the training committee of the CCB, or with the training committee of CNUE and the different training providers and institutes. Another tool is the financial tool. Of course, you want to organize such a conference, or you want to have a face-to-face seminar. The national budgets do not cater for the flights, for the accommodation, and that's where we come in. There was an evaluation a few years back of the justice program and the different effectiveness of the different strands. And for judicial training, there's a clear EU added value to have financial support, to be able to put in the same room people of different nationalities. That's also how to build, the European way of seeing the implementation of the legislation, as was rightly said earlier, that some of the exchanges also helped to, okay, we're not harmonizing legally, but at least we're harmonizing the way the practitioners are seeing things and how things should be done. And we just heard again just now from Silvina that it is done differently. It's not only a question of different regulatory frameworks. I can only encourage you to go ahead and do again such types of projects, to put together practitioners of different nationalities. If I ask my colleagues, or representative of the ESC, they will say, go ahead on AML again, you can. And in one of your conclusions was that there is a lack of training in that topic. I heard all the debates regarding the current proposal, but that aside, there is already legislation in place. There are already obligations falling on the legal profession. So the more help they get and the more it is advertised and they are supported in how to do it, the better. There are annual calls, so we call that in our jargon calls for proposals, because it is competitive. You have to apply, and there are criteria. We take the best project, so well done with this one, so that we then fund them at 90%. So normally the financial barrier is not a barrier. If you have a few partners, each will chip in a little bit, and we are there to help with this EU aspect, with the European level part, enabling you to cooperate together. And then what do you do with it? That's maybe the only thing that I may ask you, Anna, to show a slide. So it will be which slide? The fourth one, possibly, just to show you an internet address. The fourth slide. If you go down, just go, one more, stop. At the bottom, there's an internet address, which you will have, but you can also type it in your preferred search tool on internet, the European Training Platform. We are building this tool after a project, actually, of the CCBE at the time. We want it to be a repository of good training material for practitioners. So I am looking forward to the results of the contract. So we paid for it together, FISMA and DigiJust, which was a contract to train lawyers. And there was also a grant, so this time it means that it was an initiative of CNUE, also on anti-money laundering training, where they have very good manuals as well for training. And I want them there, so please contact us. So that's the last slide. You don't have to show it, don't worry, where you have my email. Last but one, where you have the Just Judicial Training. That's the email of the team. So please send us your goodies. We will be happy to further advertise all the material. We are still working. It's still a beta version of the platform, but we are really looking at advertising either the handbooks developed by our colleagues or also the good deliverables of such projects. And I will end with that. Because, as I said, it's been a long afternoon for everyone, though very interesting. So thanks a lot for the project itself and for having us today, as well as witnesses of your final conference. Please go ahead, continue disseminating the good word, and looking forward to your next project. Thank you.